A very good evening to all the learned ACGMs and CGMs from the state of Punjab, Haryana, and Chandigarh.
चलो मैं उधर से कर लेता हूँ, करो ना।
I, Harshali Chaudhary, additional
नहीं,
district
घर क्या
session
करूँगी, आ
judge,
रहा है।
come
कैमरा
faculty
कुमरा तो चल
member,
रहा है मैडम,
Chandigarh
इसमें
Judicial
दिखाई
Academy,
दे रहे हैं।
welcome you all in this webinar on scope of
सर ने चला
powers
रखा है
of
ना,
judiciary under
सबका दिख रहा है ना
securitization and reconstruction of financial
कैमरा। हम
assets
कैमरा
and
ऑन करेंगे अपना
enforcement of
तभी तो दिखेगी।
Security Interest Act 2002. And in order to enlighten us on this topic, we have amongst us the eminent jurist, Honorable Mr. Justice Shri R.K. Jain. His Lordship requires no introduction. However, if I may apprise about my Lord was born on 1st October 1958 at Hisar, Haryana, in the family of advocates. His father, Shri Gulab Singh Jain, was eminent taxation lawyer and MLA from Hisar. After obtaining degree of BCom LLB, he enrolled as an advocate with the Bar Council of Punjab and Haryana at Chandigarh, and after a short stint of practice in the District Court Hisar, shifted to Chandigarh to practice in the Punjab and Haryana High Court. He remained executive member of the Bar Association of Punjab and Haryana High Court twice, and after practicing in all the branches of law, he was elevated as judge of the Punjab and Haryana High Court in the year 2007 and retired in the year 2020. He was also appointed as monitoring member judge by the Honorable Supreme Court in the matter of, in reference, Lakhimpur violence case, and thereafter appointed as a judicial member of the National Company Law Appellate Tribunal, Principal Bench, New Delhi, with effect from 17th May 2022. I welcome my lord to this webinar, and I feel privileged to have him here amongst us to enlighten us on the topic. Before I hand over the baton to my lord, I may bring this to notice to all of the officers that we had requested the officers to attend the webinar together in video conferencing room of the District Court complex for smooth session, as it is one-to-one interaction. Chat is open. You may post your questions on the chat box, or you may ask at the end of the session by raising hands first. You're also requested to keep your audio mute. Without further ado, I welcome and also invite my lord to enlighten us on the nuances of this topic. My lord.
Thank you, Arshil. Good evening to all of you. I hope I am audible to all of you. At present, I am in Delhi, and in my chamber, I have just finished my court. So today's topic, which has been given to me for discussion with you, is the scope and power of judiciary under the SARFAESI Act 2002. I have read the Act before for the purpose of preparation of this subject today, and I tried to find out that what are the nuances of this Act for the purpose of the ACGMs and CGMs all over Punjab and Haryana, as well as Chandigarh. First of all, I will tell you about how this law of debt recovery has evolved. Because generally, all the CGMs, you being the officers, senior officers of the judiciary, are generally busy in deciding the civil suits of the nature of the declaration, specific performance, permanent injunction, etc., etc., and also in the trials of the complaints and the FIRs. This branch of law, which is now highly prevalent in the state, in the country, of the recovery of debts, because it is directly affecting our economy, and the government of India has given too much of attention to the promotion of this kind of law, which I have found only when I joined the National Company Law Appellate Tribunal. NCLT, everybody must be knowing NCLT now. It is very well known word so far as the judicial dispensation is concerned. NCLT is all over India. There are so many courts all over India. NCLAT is the appellate authority of the NCLTs, which is only located in Delhi, and there are only 4 benches in Delhi. All benches are manned by the High Court retired judges, and there is 1 bench in Chennai that is also manned by the retired High Court judge. The law of debt recovery, as judicial officers, you have seen that there were 2 phases of recovery of debt. One phase, I would say, was a soft phase, which is adopted by the bank, that is by way of writing letters to the borrower, visiting the place of business and house of the borrower, and persuasion and negotiation with the borrower for the purpose of repayment of the amount of loan with interest. The other phase for the recovery is the legal recovery. In legal recovery, generally the suit for recovery is filed, or a suit under Order 37 of the CPC is also filed, or a suit is filed by the bank or the mortgagee of the foreclosure of the mortgage property in case of non-payment of the dues. But this was a long process for the purpose of obtaining a decree from the civil court, which is not delayed by the officers. It is generally delayed by the counsels or the parties by filing unnecessary applications. But all said and done, applications are filed, decrees are delayed, and execution are further delayed. So in order to avoid the delay and for the purpose of getting the recovery of the debts, the first act which came into being was the recovery of debts due to the banks and financial institutions 1993. When this act was enacted, simultaneously the tribunals were enacted, that is debt recovery tribunal in the districts and debt recovery appellate tribunal as the appellate authority. But this was not sufficient, and ultimately the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest 2002 Act came into being. This act was brought to avoid both the court and the tribunal. The purpose of the enactment of this act was that the bank or the financial institution who has to recover the debt from the borrower or the guarantor, because if there is a borrower, sometimes there is a guarantor also. Borrower mortgages the property and obtains the loan, and sometimes for the purpose of security, some guarantor also comes forward to give the security. And as per the judgment of the Supreme Court, the creditor can recover the amount both from the borrower and guarantor independently. So in order to cut short the litigation of which may be ensued in a court of law or before the tribunal, they provided a mechanism under Section 13 of the Act of 2002 that instead of going to the tribunal or the court, the amount of debt can be recovered by the bank or the financial institution directly by issuing a notice. So that was the import of the 2002 Act. After this Act, the law further developed, and in the process of development, in 2016, they have brought Insolvency and Bankruptcy Code 2016. Now this Insolvency and Bankruptcy Code deals with the resolution of debt, by the financial debtor, and in case the debt is not paid, then the liquidation of the company. Earlier, this job was being done by the High Court judges in the High Court, where binding of applications were filed under the Companies Act 1956. But after coming into force of 2013 Act of the Companies Act, this and the 2016 Act of the IBC, the proceedings are being initiated before the NCLTs all over the country. So this is the basic overview of the debt recovery process vis-a-vis the various enactments which have come into being. Now, since today's topic is basically on the issue that scope and power of judiciary under SARFAESI Act. So once we talk of judiciary, then we generally talk of judiciary at the lower level. That is the subordinate judiciary, where the civil suits and the criminal complaints are being filed. So whether there is any provision in the Act which can be invoked by an aggrieved party for the purpose of filing a proceeding before the civil court or before a criminal complaint before the JMIC for the purpose of redressal. I may tell you in the beginning that there is section 34 in the Act which says that no civil court would have the jurisdiction. So you would definitely wonder that if the civil court does not have the jurisdiction to entertain any civil suit, then why this topic has been chosen by the Judicial Academy for today's discussion? Because it will be of no use so far as the officers in the district court are concerned. In this regard, I would just brief you, first of all, that there are certain provisions in the Act which gives power even to the CGMs, Judicial Magistrate First Class, and also the civil court to pass appropriate orders in given circumstances. Generally, with your busy schedule, you may not be getting time to go through this very technical language Act. The Act is highly technical language, because once you start reading it, the 2-3 pages you will read, you will stop, you will lose interest in this Act because the language is such. But if somebody explains to you that what are your powers and what are your duties under the Act, then perhaps it may be of any use to you. So my request to you, all of you, that please note down the provisions which I mentioned to you, and please note down the judgments which I will refer to you, so that it may be of any use to you in future. Because this type of things will never be brought to your notice by any lawyer. It has to come to you either by some kind of a educationist or through this kind of a webinar. As I have told you that section 13 is the heart and soul of this Act. The name of the Act, as you have seen, is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest, Act of 2002. It has 3 parts: securitization, reconstruction of financial assets, and enforcement of security interest. Securitization is defined under section 2Z. Section 2Z of the Act defines what is securitization. Section 2B of the Act defines what is the meaning of asset reconstruction. And section 2ZF defines the meaning of security interest. Everything as these 3 words have been used by the legislature for the purpose of framing this Act, which has been given a long name: Securitization, Reconstruction of Financial Assets, and Enforcement of Security Interest. Since I am telling you that section 13 and 14, where the role of because the word used in section 14 is the metropolitan magistrate, but as per in metropolitan magistrates are there in the metropolitan cities. So whereas other cities are concerned where metropolitan magistrates are not there, they are equivalent to the chief judicial magistrates. So section 13 deals with the power of the enforcement of the security interest. So I will read to you section 13 so that you would come to know that what is the import and what is your powers. Section 13 says, notwithstanding anything contained in section 69 or 69A of the Transfer Property Act, any security interest created in favor of a secured creditor, any security interest, that is by way of mortgage, by way of pledge, by way of hypothecation, etc., of an immovable property, in favor of a secured creditor. The secured creditor means the person in whose favor there is a security interest, and creditor means the person who has given the amount on loan or he has lent the amount to the borrower, may be enforced without the intervention of the court and tribunal by such creditor in accordance with the provisions of this Act. So the interference or the jurisdiction of the court means both civil and criminal courts, has been taken away, and also of the tribunal. Unlike the earlier Act, which was named as Recovery of Debts Due to the Banks and Financial Institutions Act 1993. And in that Act, the power has been given to the Debt Recovery Tribunal for the purpose of recovery of debts. But under section 13, the Act and Tribunal is not there. Now, as per section 13, subsection 2, the amount of loan can be recovered by the financial creditor or the secured creditor by issuing only a notice of a period of 60 days to the borrower or the guarantor. So once the notice is given, then the other party is not replying to the notice or not giving back the money which has been recalled, then further proceedings will take place. Then section 13 says, 13 subsection 3, the notice referred to in subsection 2 shall give details of the amount payable by the borrower and the secured assets intended to be enforced by the secured creditor in the event of non-payment of secured debts by the borrower. Meaning thereby, the notice has to be specific, and in the notice, how much amount is due, number one, what are the secured assets for the purpose of that amount which has been retained, and what would happen in case of non-payment of the amount by the borrower to the secured creditor. Section 13(3)(a) further provides that after receipt of the notice under section 13 subsection 2, borrower can make a representation or raise any objection to the secured creditor which shall be considered as a representation or objection. And if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, then he shall communicate within 15 days of receipt of such representation or objection the reasons for non-acceptance of the representation or objection to the borrower. So there is a clause for the purpose of, it's a show cause notice type, that if a show cause type notice is given, that is the notice recalling the amount of loan, then the party who has to return the loan, he has a right to make an objection that I am not liable to pay, your rate of interest is very high. There are many reasons he can raise the objection, and that objection will be decided by the creditor, but that order will not be amenable to challenge in any court of law. Then comes the main provision of section 13 subsection 4. This says, in case the borrower fails to discharge his liability in full within period specified in subsection 2, that is the notice given under section 13 subsection 2, 60 days time, the secured creditor may take recourse to one or more of the following measures to recover the secured debt. Number one, take possession of the secured asset or of the borrower, including the right to transfer by way of lease, assignment or sale of realizing the secured asset. Take over the management of the business of the borrower, including the right to transfer by way of lease, assignment or sale for realizing the secured asset. So there are two ways in the hands of the secured creditor, that first he can take possession of the mortgage property. Earlier the property, if it is a simple mortgage, the property is in possession of the mortgagor. So only the mortgagee rights are with the mortgagee. So once the section 13 subsection 4 action is taken, then the mortgagee has a right to take possession of the mortgage property. Then it can also take over the management of the firm or company who has mortgaged the property for taking the loan. After taking these steps, although the section is very lengthy, I will not go into this, but suffice it to say that the main section is 13.2 and 13.4, which you always remember, so far as the SARFAESI Act is concerned. And most of the judgments on section 13.2 and 13.4 are there. Whether when I was in the High Court also, I had this subject, and there I had to give so many judgments on 13.2 and 13.4 only. Now, thereafter comes section 14, where the power of the CGM or the DM is there. This says, where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing. So if some request come to you orally, that request is no request under section 14 of the SARFAESI Act. The chief metropolitan magistrate or the district magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate, or as the case may be, the district magistrate shall, on such request being made to him, take possession of such asset and documents relating thereto. The request is to be made by the financial creditor or the secured creditor. That request has to be in writing. It has to be, the property should be within your jurisdiction, and then you can take the possession of the property concerned. But there is a proviso to this section 14 subsection 1, which says, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring that. So the application has to be supported by an affidavit, and that too by a duly authorized person of the secured creditor. Now this affidavit, there are about 9 points given in the statute itself, which should be mentioned in the affidavit itself. This says that, and then once supposing it is, the application is filed, affidavit is filed, it has the affidavit and application comes to you, and then what you have to do. Then this says, the proviso says what you have to do. Proviso says, provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured asset within a period of 30 days from the date of the application. Now, here is a case where the satisfaction of the officer concerned, who has to pass the order for taking possession, and for the purpose of satisfying himself on the basis of the application supported by an affidavit, he has to look into the affidavit and also the provisions of the Act, whether the affidavit talks about the provisions of the Act and whether it satisfies the conditions which are mentioned in the affidavit or not. Then section 14 subsection 2, which is also very important, which you may note down, for the purpose of securing compliance with the provisions of subsection 1, that is section 14 subsection 1, which talks of the taking possession. The chief metropolitan magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may in his opinion be necessary. So power it is not a toothless provision. Powers are given for the purpose of taking possession also. One can understand that power is given, so where a responsibility is given upon the CGMs, the officer concerned, whether he is a CGM or is a DM or is a metropolitan magistrate, that he will go into the application, he will look into the affidavit, if he is satisfied with the contents of the affidavit, only then, that too within a period of 30 days, he will take his action for the purpose of taking possession. Section 14 subsection 2 says that for the purpose of enforcing his order to take possession, he can use force also. This is what the section 14.2 stipulates. Then section 14 subsection 3 is also important. No act of the chief metropolitan magistrate or the district magistrate, any officer authorized by the chief metropolitan magistrate or district magistrate, done in pursuance of this section shall be called in question in any court or before any authority. So whatever action is taken by you under this provision, it will not be called in any court or before any authority. But it doesn't mean that writ court it will not go to the writ court. That is extraordinary jurisdiction of the High Court. But so far as the normal civil courts are concerned, it will not go there. This is the import of section 14, where you have been given, the CGMs or the CMMs have been given the power for the purpose of taking possession on behalf of the property of the mortgage property or the secured property in which there is a secured interest of the secured creditor. Having said that, I will take you to now another aspect of this act. The rest of the provisions are not meant for you, because it is useless if I talk to you about other provisions which are not meant for you, and it's meant only for the tribunal where the matter has to go either by way of original application or by way of securitization application. There is a provision in this act, there is a chapter in this act, that is chapter 4, which talks of central registry. It is very, very important in the act. In this chapter has been created by the legislature by creating a central registry where the parties have to mention to the central government about the security which has been created by the bank. A loan has been given by the financial institution or the bank, and what kind of security has been created by them for the purpose of securing their debt. There is a provision which says section 23 of the Act of filing of transactions of securitization, reconstruction and creation of security interest. The particulars of every transaction of securitization, asset reconstruction or creation of any security interest shall be filed with the central registrar in the manner and on payment of such fee as may be prescribed. So this is very important, section 23. Similarly, section 24 is section 24, section 25 and so on and so forth. There are 5-6 provisions like section 23, 24, 25, 28 and 29, which are for which a cognizance of offence can be taken. Now, section 29 of the Act deals with the offences. Now, there would be complaints before you, and section 29 says any person contravenes or attempts to contravene or abets the contravention of the provisions of this Act or of any rules made thereunder, he shall be punishable with imprisonment for a term which may extend to 1 year or with fine or with both. So the Act provides that if there is any of the provision of the Act or the rules, it is a very sweeping provision which has been provided, that if any provision is contravened or any rule is contravened, then there would be a punishment for 1 year. So who will take the cognizance now and how? That is section 30. No court shall take cognizance of any offence punishable under section 27 in relation to non-compliance with the provisions of section 23, 24, 25 or under section 28 or section 29. I have read to you section 29, that is pertaining to the offences, or any other provision of the Act except upon a complaint in writing made by an officer of the central registry or an officer of the Reserve Bank, generally or specially authorized in writing in this behalf by the central registrar or as the case may be the Reserve Bank. Section 30 subsection 2 says no court inferior to that of the metropolitan magistrate or judicial magistrate of the first class shall try any offence punishable under this Act. So please note down this, that section 30 subsection 2 gives power to you or the jurisdiction to you to entertain an application entertain a complaint which may eventually be made in writing by an officer of the central registry. Under the central registry is created under chapter 4 of the Act, or an officer of the Reserve Bank of India who is authorized in writing on behalf of in this behalf by the central registry or as the case may be by the Reserve Bank. For the alleged offence of section 23, 24, 25, 28 and 29, if these provisions are violated, then some complaint can come to you and then you can try that complaint. Supposing some complaint comes to you under section 22 or section 26 which is not mentioned in section 30, you can straightway, if you know about it, you can straightway say this complaint is not maintainable because you have heard somewhere or you have read somewhere. So this is the purpose of this webinar or this discussion, so that somebody may tell you that what kind of a complaint you can entertain under which provision of law and what is your jurisdiction. Section 30 subsection 5 may also be noted, please. This says no complaint shall be filed against any person in default in any court pertaining to any failure under subsection 1 in respect of which any penalty has been imposed and recovered by the Reserve Bank of India under this section. So supposing the Reserve Bank of India has already recovered some amount, then no complaint can be filed before any court. Court means the criminal court. Where any section 30 subsection 6 further says where any complaint has been filed against a person in default is the borrower, in the court having jurisdiction, no proceeding for imposition of penalty against that person shall be taken under this section. So this is with regard to the offences under chapter 4 and the cognizance of offence and who will try. Then there is a provision, section 30D, recovery of penalties. Section 30D. Section 30D is a very lengthy provision, but for your purposes, section 30D, subsection 10 and subsection 11 are relevant. I am mentioning especially all these provisions so that as an officer, you need not to, and you have some interest. Supposing tomorrow some matter comes to you pertaining to your jurisdiction, then you know that these are the only sections in which the matter can be looked into, otherwise there is no other provision. Section 30D deals with recovery of penalties. Penalty has been imposed. Penalty has been imposed under section 30, but how this penalty is to be recovered then? So section 30D subsection 10 says the Reserve Bank may enforce recovery of recoverable sum through the principal civil court having jurisdiction in the area where the registered office of the or the head office or the principal place of business of the person in default or the usual place of residence of such person is situated, as if the notice issued by the Reserve Bank were the decree of the court. It's a very important provision, please. This says, supposing penalty has been imposed of 10 lakh rupees or 50 lakh rupees by the Reserve Bank of India, then how it is to be recovered? It is to be recovered by the principal civil court. Principal civil court is the district judge having jurisdiction in the area where the registered office of the head office, where who would be the respondent? Then how you will find the respondent? Like section 20 of the CPC about the cause of action. This says registered office or the head office of the or the principal place of business of the person in default. Section 22, section 20, subsection C of the CPC, or the usual place of residence of such person is situated, as if the notice issued by the Reserve Bank were a decree of the court. When the Reserve Bank of India will issue a notice to the penalty imposed to the borrower or the defaulter, that would be a decree, and that decree will it will present the decree before the principal civil court of the area concerned, and the principal civil, it is the duty of the principal civil court to get that amount recovered for the Reserve Bank of India. Section 30D(11). No recovery under subsection 10 shall be enforced except on an application made to the principal civil court by an officer of the Reserve Bank authorized in this behalf, certifying that the person in default has failed to pay the recoverable sum. So this says that it cannot be except an application is made that the person to whom the notice has been given, notice must be carrying some time period for the purpose of paying the imposed penalty, and during this period the penalty is not paid, then he will certify that the person in default has failed to pay the recoverable sum. So a certificate has to be there along with the application which is presented before you as the civil court. Now section 32 of the Act is also of your interest. This is protection of action taken in good faith. No suit, prosecution or other legal proceedings shall lie against the Reserve Bank or the Central Registry or any secured creditor or any of the officers for anything done or omitted to be done in good faith under this Act. Supposing somebody, the Reserve Bank of India has done it, Central Registry has done it, and somebody files a suit before you that they have wrongly done it, then this says that protection of action taken in good faith. If it is taken in good faith, then no suit lies. Then this sine qua non for you to find out whether the action has been taken in good faith or is a malicious prosecution. If it is a malicious prosecution, then yes, you can entertain the suit. But if you find that the action has been taken in good faith, then you have to go into the issue. What is the meaning of good faith and what is the meaning of the malicious prosecution? The last provision in this Act, there are only 42 provisions in this Act. The last, for your interest, which has been found by me, is that section 34, which deals with the civil court not to have jurisdiction. I have started my discussion today by saying that though there is section 34 in the Act which says that civil court will not have the jurisdiction, But still, there are so many provisions I have read to you, which I have found after going through the entire act very minutely, that what are the places where your jurisdiction is there for the purpose of redressing the grievance of the secured creditor. This says no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under this act to determine, and no injunction, please note down, no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or under the recovery of debts due to banks and financial institutions act 1993. After going through this provision, I just wondered whether there is any judgment of the Supreme Court on this issue, section 34, where the Supreme Court has said that de-horse section 34, you have the power to entertain a suit and pass an order of injunction. For that matter, I have found two judgments. You may note down these two judgments. Perhaps it may be of any use in future in your career. The first judgment on this issue is a very celebrated judgment of the Supreme Court, and you will find it many times whenever a matter would come to you. It is the citation of judgment is Mardia Chemicals Limited and others versus Union of India and others. This is reported as 2004, Volume 4, SCC 311. So in this judgment, basically this was a case in which the virus was challenged, but ultimately the Supreme Court has propounded a situation where the whole section 34, the suit has been entertained. The second judgment is a recent judgment by Justice B.R. Gavai, that is Civil Appeal number 2924 of the year 2023, decided on 18th April 23. It is the latest judgment of the Honorable Supreme Court, Punjab and Sindh Bank versus Frontline Corporation Limited. In this case, I will not go into the merits of the facts of the case because the judgments are very lengthy. But this Supreme Court has held, which I will read to you, may be of any use to you in your future career. However, to a very limited extent, jurisdiction of the civil court can also be invoked where, for example, the action of the secured creditor is alleged to be fraudulent, or his claim may be so absurd and untenable which may not require any probe whatsoever, or to say precisely to the extent the scope is permissible to bring an action in the civil court in the cases of English mortgage. Now this says, to a very limited extent, jurisdiction of civil court can also be invoked where, for example, the action of the secured creditor is alleged to be fraudulent. All through I have mentioned that this debt recovery laws are meant for the secured creditors. And who is the secured creditor? Gone are the days of money lenders, artiyas, etc. Because though they are not those kind of secured creditors, because they don't go to the DRT, etc. They file suit under section under order 37. Order 37 of the CPC deals with the summary procedure. This says courts and classes of suits in which the order is to apply. And it says, subject to the provisions of sub-rule 1, the order applies to the following classes of suits, namely suits upon bills of exchange, hundis, and promissory notes. Suits in which the plaintiff seeks only to recover a debt or liquidated demand in money payable by the defendant with or without interest arising on a written contract or on an enactment where the sum sought to be recovered is a fixed sum of money or in the nature of debt other than a penalty, or on a guarantee when the claim against the principal is in respect of a debt or liquidated demand only. Suit for recovery receivables instituted by an assignee of the receivable. So these type of suits are filed in the civil court. But the secured creditors, like the banks or the non-banking financial institutions, In this, I may share with you that
Yes.
as I was telling you, can you hear me? Am I audible to all?
Yes, yes, your lordship, you are audible.
Yes. So as I was telling you that in the this insolvency and bankruptcy code, now in this you will find there are the big players are there of the in which the amount involved in each case is not less than 10,000 crores of rupees. The stakes are so high. The stakeholders are not only the Indian big companies, the stakeholders are the foreign investors also. So these are the secured creditors. They lend the money, whether it is a asset reconstruction company or it is financial institution or it is a banking company. All these the companies which are giving the loan or lending the money to the borrower, those are covered for the purpose of recovery of debt regime, which is created by the enactment of 3 acts, as I have told you already. So, for that matter, as I was telling you, that injunction can be granted by you by reference to these 2 judgments of the Mardia Chemicals as well as the Punjab and Sindh Bank. Now, there are other judgments also on certain issues, although there are so many judgments, but because of the paucity of time, I could lay my hands only on few judgments, which I can tell you so that you can note down the judgments. One of the judgments is Asset Reconstruction Company Limited versus State of Haryana. Why I am referring to this judgment? This judgment, you may find out the citation from your this the uh, from the internet. This says the issue was in this case whether the district magistrate is competent to review his own order. Now the issue was that, like, you are the authority, supposing you are the authority to whom the matter has come for the purpose of taking possession and you have passed some order, whether you can pass an order of review also. The decision was that there is no scope for exercising the power of review. This is regarding this judgment. It has also been held in the case of Standard Chartered Bank versus Noble Kumar by the Honorable Supreme Am I audible, please?
Yes, Your Lordship, you're audible now.
Yes. So there is another case which you may note down, please. Kotak Mahindra Bank Limited versus Girnar Corrugators Private Limited. Kotak Mahindra Bank Limited versus Girnar Corrugators Private Limited. In this case, the Supreme Court has held that the Nayab Tahsildar, the district magistrate, or even the chief judicial magistrate do not have the jurisdiction to adjudicate disputes between the creditors and the debtors. It might have happened that while deciding an application under section 14, the district magistrate or whatever the authority to whom the power to take possession was assigned by the district magistrate, that is the Nayab Tahsildar, might have done something wrong, meaning thereby that he might have decided the issue between the creditor and the debtor. The matter reached to the Honorable Supreme Court ultimately, and they have held that they are nobody to decide, because the reason is that decision is already taken under section 13 by issuing a notice under section 13(2) of period of 60 days that I want my money back. It's so simple. Like you have seen that under the Transfer Property Act, in a matter of lease under section 106, you have to give a notice of 15 days and ask for the property to be given back. To overcome that issue of that lease, etc., that issuance of notice and taking back the property, the Rent Act came into being, where the protection was given to the tenants from being evicted by the landlord on their whims and fancies. Anyway, there is another case of Allahabad Bank versus District Magistrate. This was also with regard to the scope and power of the District Magistrate. So there are these type of cases. There is another case, Phoenix ARC Private Limited versus Vishwa Bharati Vidya Mandir. In this case, the Honorable Supreme Court has held that the writ petitions filed by the borrowers were an abuse of the court of process. The writ petitions were not found maintainable at the hand of the borrower in respect of section 14. So all these issues which I have discussed with you or I have narrated before you are pertaining to the powers which are specifically mentioned about the court or the complaints. I have read each and every word of the statute, all the sections, in order to find out where the word court or the complaint has been used by the legislature. Because wherever court is there, you are there. Wherever there is a complaint is there, you are there. But for other things, that is for the purpose of finding out whether the notice was within 60 days or not, whether the reply within 15 days were not there, it is all the jurisdiction of the tribunal. That is the debt recovery tribunal where the petitions are being filed. So this is a short narration for the purpose of briefing you about the scope and power of the judiciary, that is our judiciary in the district courts, so far as SARFAESI Act 2002 is concerned. So if any question which is coming to your mind, you can share with me on your chat box, in the chat box, which I will answer after getting the question, so that I may not be also faulted in answering your question. Or anything you wanted to ask me right now, you are free to ask. Okay, Harshil, I think nobody want to ask anything.
Yes,
so thank
yes,
you very
Your
much.
Lordship.
Thank you very much for this discourse.
Thank you very much, my lords, for this amazing session, and I hope every one of us has been enriched with the same. I thank my lord for taking out his valuable time for this session. I thank you all the learned attendees. The session would also be available on our YouTube channel for further reference. So thank you very much to all of you, and till we meet again, namaskar. Namaskar, Your Lordship.
Thank you very much. Thank you to all of you for giving me patient hearing. Thank you.